record this. Hello, everyone. Welcome to today's emergency meeting on the license to practice law. Um, so we're going to start this off by this meeting by just saying this is going to be public, right? I'm going to put this out as public everywhere as I can. So I'm going to start this out by saying, "Fuck you, Trip Stroud, Attorney Trip Stroud in Wisconsin." Okay. I'm saying this from the beginning of the get-go because, right, is that we all have a right. We all have, according to the Constitution, we are afforded access to courts, right? So this whole idea that you have to have a lawyer to do this, to do that is absolute bullshit. Okay? Because the Constitution, the 14th Amendment, says that we are to have access to courts. Okay, so I'm going to start off there, 14th Amendment, right? And I'm going to start off talking about the 14th Amendment and um, and what this is all about. Okay, I found this. Um, I found this earlier today, and I want to share it with you. Okay, so this here is Cornell Law School. Okay, this is an amend. This is the 14th Amendment. This is it's basically a Supreme Court opinion. Okay, so all persons born or naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and the state from where they reside. No state shall make or enforce any law in which shall abridge the privileges or immunities of citizens in the United States, nor shall any state deprive any person of life, liberty, property without due process of law, or deny any person with its jurisdiction with the equal protection of these laws. Okay. In Bodie v. Connecticut, Justice Harlan carried a majority of the court with him in using a due process analysis to evaluate the constitutionality of a state's filing fees in divorce actions that a group of welfare assistance recipients attacked as preventing them from obtaining divorces. The court found that when a state monopolized the avenues to uh, pacific settlement of a dispute over a fundamental matter such as a marriage, only the state could terminate the marital status. Then it denied due process by inflexibility, imposing fees that kept some persons from using that avenue. Justice Harlan opinion averred that the factually neutral law or policy that did in fact deprive an individual of a protected right would be held invalid, even though, as a general proposition, its enforcement served a legitimate governmental interest. The opinion concluded with the cautioning observation that the case was not to be taken as established a general right to access to the courts. Okay, so what this is saying is that they cannot create an environment where people don't have access to the courts. Okay. So let's just say you're indigent. This is why that they have waiver of fees. Every single court has a fee waiver form, right? Because they cannot deny you access to the court. Equity says that there cannot be a wrong without a remedy. Okay. That means if the remedy is in court, they can't deny you. They can't say, oh, because you can't afford to file a court case, you can't be heard. They can't do that. Okay. They also cannot tell you that you have to have a lawyer to access these courts. Okay. So, what happened was this attorney doesn't have a case, right? He's an idiot, has no case. His client is abusive. His client has broken the law since he was a teenager, and he is trying to deprive me of property, and this lawyer is helping him. He doesn't have a case. He cannot win on the merits. So he keeps trying to get things dismissed on technicalities. So what he did is he contacted Georgia, because that's the state I live in, and he told them that I was practicing law without a license, and then he provided all this information that he thought was going to conclude that I had broken the law in Georgia. So I'm going to show you what the letter from Georgia was, okay? So this is a letter from Georgia, which I find interesting. Instead of them titling the letter like Kent Stark in all capital letters, whatever, it's like this. And it's like this because I filed a name change case in Georgia and I changed the name from all capital into spelled this way. So I think it's funny how Georgia tried to dismiss that case, but yet now they're spelling my name correctly. So um, this is, the case numbers, letter in reference to a complaint received by the state bar concerning you and your possible unlicensed practice of law. So who is you, right? So let's keep going. This office has been made aware of a potential UPL activity involving you and a business operated by you, Stark Financial Group, DBA Stark Law Firm. Okay. First of all, Stark Financial Group and Stark Law Firm are owned and operated by a business trust, right? It's not owned by me, it's not operated by me, right? It's kind of like we have the right to travel, right? But they try and get us to say that we're an operator. You've heard me say this to you 1,000 times, but what is a letter? When you get a letter, especially from a lawyer or the bar association, what is a letter? Why do they send a letter?
To get you to accept an offer.
Yeah, it's an offer to contract,
Right.
right? They need you to agree. They need you to contract with them, right? Well, this idiot already called me on the phone. This Kent Wong. So Mr. Wong called me on the phone and he said that he had this report that I was practicing law without a license. And I was like, who? And he was like, oh, it came from Wisconsin. I was like, oh, that's great. And I said, so what like what do you want? Right? I was like, well, he says, I'm investigating that you're practicing law without a license. And I was like, okay, well, I don't know what to tell you because, first of all, I'm not practicing law without a license. And I said the next thing is that I don't know who you're directing this at, right? And he said, "Well, I'm hoping that you would have a friendly conversation with me." And I said, "Well, the first thing is that I know that if you had any evidence against me, you wouldn't call me on the phone and want to have a conversation. You would just charge me." And I said, "So what that tells me is you ain't got shit." And I said, "And so the next thing is you need me to have a conversation with you to give you all kinds of evidence so you can charge me with a crime." And he was like, well, I was hoping that you would cooperate. And I was like, I'm not going to cooperate. I'm not your friend, and I'm not going to give you evidence so that you can manipulate it and twist it and play games with me. So what I'm telling you, pretty please with sugar on top, is to fuck off. And he's like, well, you can be charged as a crime. And I'm like, I've been to fucking jail before. I'm like, get on with your rat killing. Whatever it is that you think you can do, just do it. Right. And so that was that conversation. That was like weeks ago. And then this is the letter that came out. So this is his offer to contract. Right. So the statutes pertaining to the unlicensed practice of law in Georgia are enclosed for your review. Again, he's trying to get me to contract. right? So he sends me the statutes. If I don't respond, then what is that? If he sends me the Georgia statutes on not practicing law without a license and I don't respond, what does that do?
Well, failure.
That's
uh,
acquiescence.
Yeah, you're
Acquiescence.
acquiescing to their laws.
You're admitting guilt. Yep.
Well, not necessarily admitting guilt, you're admitting that they have jurisdiction over you.
Does it put
Okay.
you in dishonor?
Well, no, the thing that in his eyes, what puts me in dishonor is the name, right? The fact
Oh,
that
okay.
he's addressing me with that name is what puts me in dishonor because he thinks that they own it, the state of Georgia, right? Because when you're a resident of a state, that your estate moves there, right? And so then they have jurisdiction over your estate, right? And so that's what he thinks. It's not accurate, but that's what he thinks. Okay. So rendering the furnish of legal service advice and representing third parties in a court of law, preparing pleadings or papers and incident to any action of the court on behalf of another, um, holding oneself outside the entitled practice of law. The statutes further provide that only a duly licensed attorney may hold themselves out of helping entitled to practice law and further prohibits non-attorneys from using the title lawyer, attorney, attorney at law, or equivalent terms in such manner as to convey the impression that the entitled to practice law, advertising one has, owns, conducts, maintains an office for the practice of law is similarly prohibited. Okay, so uh, now they're trying to say that we have these words copyrighted, right? So the word lawyer, attorney, or attorney at law, right, is saying that it has these words are copyrighted, right? Please note that the unlicensed practice of law is a criminal offense under Georgia, under OGA 15, 1956A. Any person found to be violating the aforementioned UPL statutes shall be guilty of a misdemeanor. Accordingly, this matter could potentially be referred for possible criminal prosecuting following the committee. All right. If that was going to happen, they would charge me and not send me a letter. Okay. Enclosed are 3 copies of a cease and desist affidavit. This is the best part, right? Enclosed are 3 copies of a cease and desist affidavit. Should you choose to sign this affidavit, please do so in the presence of a notary public and return the 2 original copies to me in the enclosed self-addressed stamped envelopes. You may retain a copy for your records. Should we receive a signed cease and desist affidavit, and you should remove all references to the Stark Law Firm and cease offering legal services to the public. I may recommend to the committee to close the matter. So you understand that if I sign the affidavits and send them back, what am I doing?
That's a statement of truth. You're admitting guilt.
Yeah, they're like,
Yeah.
here,
That's a
sign these
trap.
affidavits, admit you're guilty. I'm
Jeez.
going to read them to you in a minute. Admit you're guilty, and we'll refer it to the. So this is just more his attempts to collect information, right? And
Yeah.
it's just hilarious, right? Um, so then he goes on to say, right? Is we trust the enclosed statutes will be both helpful and beneficial to you in the future. Okay, we trust the enclosed statutes will be both helpful and beneficial to you in the future. So what is he saying in that sentence?
He's trying to trick you into thinking it's beneficial for you. It's like a real
Well,
sick
the second word
perversion.
is trust.
Yeah, but he is trying to establish a contract trust based on
Yes,
these
he's trying to
affidavits.
establish a trust and make themselves the beneficiary.
Jeez.
Right? So just I fucking hate lawyers. This is the best. All right. So we trust the enclosed statutes. In other words, I'm creating a trust. The enclosed statutes are the res property of the trust, and it'll be both helpful, trustee, and beneficiary for the future. He's trying to establish a trust, right? A one where I'm helpful, right? The trustee. We appreciate your concern in this instance in the matter. If you have any additional questions, okay, Kent Long, investigator, right? So then here's the statutes, which you can look them up and read them if you want. I'm not reading them. I didn't read them when he sent them. I'm not going to read them now. Um, okay, so here's a cease and desist affidavit. Before me, the undersigned notary duly authorized by law to administer oath comes Kent Nicholas Stark, who, after first being duly sworn, deposes and states as follows: I am not a duly licensed attorney under the laws of the state of Georgia, and I am not a licensed member of the bar of Georgia. I understand that it is unlawful under the laws of the state of Georgia to practice law. I understand that it's a crime under the laws of the state of Georgia. And then it goes through each of the details that he's bringing up. I to assume or to use or advertise the title of lawyer, attorney, or attorney at law or equivalent in terms is language. So I didn't use any of those terms, so that's what's funny. To advertise that, I understand that unless otherwise provided by law or by rules promulgated by the Supreme Court, it shall be unlawful for any corporation, voluntary association, or company to perform any of these acts listed. I agree that in the future I will not engage in the authorized practice of law, blah, 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 right? So the whole thing is like it's all a setup, right? So this is how this is how I answered them. So first of all, I'm coming at them as the authorized representative. Remember, don't ever come at them as you, right? Because he's trying to make this about you in this letter. So you don't come at them as you, you're the authorized representative, right? So Kent Wong, staff, State Bar Association, I acknowledge in the receipt of your correspondence dated July 21st, receipt of your correspondence shall not be construed as an acceptance or contents your asserted jurisdiction, your legal conclusions, or any other obligation arising therein. I respectfully decline your request to execute the enclosed affidavit. I decline and reject the proposed affidavit in its entirety. I decline and reject the jurisdiction asserted in the State Bar Association over my lawful education activities concerning common law, equity, constitutional principles, trust administration, and legal history. Accordingly, I do not recognize any obligation to execute documents prepared by your office or to accept any legal conclusions asserted in your correspondence. My work consists of educating individuals regarding common law, equitable principles, constitutional rights, trust administration, and legal history. Education concerning legal principles is fundamentally different than acting as an attorney for another person. My purpose is to educate individuals regarding their own rights, responsibilities, and the historical development of the common law and equity, not to appear as counsel or to practice law on behalf of another. The constitutional guarantees secured by the 14th Amendment to protect meaningful access to the courts through due process clause, as recognized in the constitutional analysis accompanying the 14th Amendment. The Supreme Court has recognized that meaningful access to courts is protected in appropriate circumstances under the Due Process Clause, including Bodie v. Connecticut 401 U.S. 371, 1971. While subsequent decisions have discussed the scope of that doctrine, the underlying constitutional principle remains that fundamental constitutional rights may not be denied through the arbitrary governmental action. Likewise, the authorities I have studied recognize longstanding constitutional principles, including Schwer versus Board of Bar Examiners, recognizing that the state may not exclude a person from a practice of law in violation of the Due Process Clause. Meyer versus Nebraska, recognizing that the liberty protected by the Constitution includes the right to pursue a lawful occupation. Miller versus United States, recognizing that the exercise of constitutional right cannot itself be transformed into a criminal act. Shuttlesworth versus Birmingham, recognizing that constitutional liberties may not be nullified merely by converting them into privileges. Brotherhood of Railroad Trailmen versus Virginia, Virginia State Bar, together with regulated authorities recognizing constitutional protections afforded to individuals seeking assistance in exercising legal rights. These constitutional protections exist to preserve the liberty of the people, protect meaningful access to courts, and prevent the arbitrary deprivation of constitutional rights through administrative or statutory action. In addition, my work is grounded in the long-standing principles of equity. Courts of equity have historically recognized that equity regards substance over form, equity will not suffer a wrong without a remedy, and equity acts on the conscience of parties rather than merely the form of a proceeding. These principles have existed for centuries to ensure that the justice is administered according to substance rather than technical form, and that the constitutional liberties remain meaningful rather than illusionary. Nothing in this educational activities is intended to interfere with lawful authority of the courts or misrepresent myself as a licensed attorney. Rather, my objective is to educate individuals concerning constitutional principles, equitable rights, common law history, and the lawful administration of justice so that it may be better under, may better understand and exercise their own rights. Accordingly, I decline and reject the proposed affidavit in its entirety. Nothing contained therein creates any obligation upon me, nor do I recognize any duty to execute or respond to the documents issued pursuant to jurisdiction I do not recognize. Nothing contained in your correspondence alters my constitutional right, equitable rights, common law rights, or my position concerning the jurisdiction asserted by the State Bar of Georgia. Your legal conclusions are rejected. Nothing contained in this correspondence shall be construed as any waiver of constitutional rights, statutory rights, equitable rights, common law rights, jurisdictional obligations, or other rights and defenses available to me, all of which are expressly reserved. Respectfully dated July 25th. So then I took their letter. These are the originals. And then I printed right on the front of the letter, rescission, right? So I got right to rescission. Your contract is not accepted. It's under violation of color of law, 18 USC 241 and 242. This is why I'm coming as, you understand this now? Why am I coming as the authorized representative? And not as the person, not as a individual. Why am I coming as the authorized representative?
Authorized representative, the same as an attorney in fact in law,
Right.
but it
So,
is also an accommodation party.
yeah, the Constitution says, Article 1, Section 2, that when I reach the age of majority and uh, claim my lawful claim of title of U.S. representative, right?
It's the same in UCC 3402 B1, authorized representative that does not carry liabilities.
Right. But it's also because I can't, okay, the beneficiary has no standing in commerce, right? So you have to
Yep.
come at them as the U.S. representative. I'm coming at them in the name of the people. So they are asserting a crime against the people. I'm not saying you violated my 241 and 242. I'm saying they're violating 241 and 242 against the people by sending that letter and representing themselves as a public agency, right? So that's how you have to come at them. That's why we use the U.S. representative or the authorized representative, right? So the right to rescission, the contract is not accepted in a violation of law. So then I quoted Bodie versus Connecticut, while subsequent decisions we have discussed, and the 14th Amendment, and then it's rescission. And every single page, this is all originals that they sent me. Okay. Understand this also, right? Is that the paper that they use and the ink they put on their paper is what? You remember me telling you this? That's their intellectual property.
Oh, okay.
When they send you a letter and they use their paper and their ink, It's their property. So when you keep it, you're accepting consideration. So you have to take their property and print shit on it and send it back. The originals. Make copies of what you're doing, but right? So everything, the laws they sent, right? And then their stupid affidavit, right? The whole thing. Now I did it on all three of them. They sent three of them, but I'm not gonna waste my time putting three exact copies in here. So so then I take all that stuff and they sent me, this is what's beautiful about it. They sent me a self-addressed stamped envelope from the bar association. So I'm gonna send them all this shit back in their own envelope. So this is going to be available to you all so that you can read over these. You want to read these case laws. You want to read over like the 14th Amendment, these different assertions that the Supreme Court has ruled on these different amendments so that you can understand like why, all this is happening is that as you read in the letter, it's not like they're saying that I can't do what I want to do. They're saying that you can't use our names. You can't use our laws. You can't, and that's the whole thing is to be an attorney or to be a lawyer is they have everything copyrighted. So you don't have the authority to use their laws, right? You have the authority to use the Constitution. You have the authority to use common law. You have the authority to use equity, but they have their statutory laws copyrighted. So that's what they're coming back at you with copyright infringement. So you have to come back. You have to send their copyrighted laws back to them, right? Anything they send you, you got to send back, right? I do the same thing with the IRS. Everything the IRS sends me, I put rescission on it and I send their paperwork back to them, right? Everything's an offer to contract. And I hope they charge me. I hope they fucking show up at my house and try and charge me with practicing law without a license so I can make their freaking court a mockery. Right? So I can go in there and I can talk about all these things and I can use it as another fulcrum to make our stand in this movement. Right? This is what we do. This is how we do it. Right? Is not by like being dishonorable and doing some of the other stuff out there or like, fighting with cops on the street and shit like that. This is how we do it. Let them make let them make a claim, right? Let them take you into court and then stand on your square. I hope they charge me. They ain't gonna. They ain't gonna because if they were, they would have, right? And that's just this is what this is all about, is that you got to take these things and you got to address them properly and write the right letters, and then you send the stuff back. And then you keep administrative record of it, right? So, um, you guys got questions about this?
So how did you establish the law firm? Like I know Brandon John Williams did the same thing. You established it as LLC under the business trust, or did you do it as the another trust under the business trust?
It's a LLC, but
Mm-hmm.
it's a DBA.
Okay. So you're doing like Stark Financial DBA as Stark Law LLC, law firm LLC, right? Because I
Yeah,
wanted to
and
do the
there's a
same thing for myself.
yeah, and there's a there's a I'll show you guys this. There's a document that is publicly put out um, about this. So, uh, So, first of all, nothing that is in this is in those words. You understand? It doesn't say that he can't use that I can't use the word law or firm. He says attorney at law, right? So all information, materials, communications, and services provided as Stark Financial Group LLC doing business as Stark Law Firm are for educational, informational, and private purposes only. No legal advice. Nothing provided in the Stark Financial Group or Stark Law Firm constitutes legal advice, legal representation, or the practice of law in any jurisdiction. No attorney-client relationship is formed by accessing, receiving, or using information or services. Not a law firm. Stark Law Firm is a trade name used for branding and private educational purposes only. Stark Financial Group is not a licensed law firm, and no representatives are acting as licensed attorneys unless expressly stated in a separate written agreement. Educational and private membership contract. All content is presented with a private educational and membership-based setting and is intended to share general knowledge, research, and personal perspectives regarding financial, administrative, and legal purposes. Independent responsibility. You are solely responsible for your own actions, decisions, filings, and any information provided. You agree to conduct your own due diligence and, where appropriate, seek advice from a licensed attorney or qualified professional. No guarantees, right? Stark Financial Group makes no guarantees, warranties, or representations regarding outcomes, results, or effectiveness of any strategies, documents, or information provided. Laws vary by jurisdiction. Information provided may not apply to your specific state, case, or circumstance. Hold harmless. By using this information, you agree to hold harmless Stark Financial Group, its affiliates, members, managers, and agents, and any and all claims and liabilities or damages or losses arising from your use or reliance on the information provided. Okay, so this is the legal disclaimer that's put out there. So it's quite the opposite of everything that they're accusing. And so that's like how it's done, right? And it's not intended to be a law, it's not intended to give legal services.
Did you feel
And I even,
compelled sending that form to them in response to their letter, or that
well,
would
it's
constitute a
on the
contract?
website. It's on the website, but
Oh, so it's
I'll send
publicly
them a copy
accessible.
of I'll send them a copy of the letter so that they
Gotcha.
know that, yeah. And I'm not changing shit. I'm not changing shit. I'm not changing the name. I'm not taking anything down. I'm not cease and desist. I'm not doing anything, right?
I
Because
thought that maybe if you'll send that letter, it will constitute a contract, entering into a contract. What will you think?
no,
No?
it's a disclaimer, right? The intent
Gotcha.
of the letter is to disclaim everything that they're saying.
Kind of like a
But
rebuttal,
I'm
right?
also not in their jurisdiction and I don't claim to be in their jurisdiction. So I more than likely won't send the letter. I'll send the letter I wrote, but I'm not going to send that because I don't owe them an explanation, right? There was one really cool thing the other day. Somebody sent me a video and it was like some guy in court and he was like, they were like, the judge asked him something. He's like, I don't answer questions. He's like, I don't know who you think you are. I don't answer your questions, right? I'm not in your jurisdiction.
What was the judge's reaction to that?
He left the bench, and so the guy took control of the bench. He said the judge left the helm. Oh my God, it was funny. But it's just it's the thing is that like you got to really like understand like the backbone of all this and what you're doing and how to like operate through this um because it's about standing on your square. They need you to give them what this guy's trying to get me to give them. I mean, it's desperate. How fucking desperate can you be that you send somebody an affidavit with a self-addressed stamped envelope and said, "Oh, go get this executed by a notary." Do you know how many people would do that? That would go do that because they think that they're going to get in trouble? Fucking charge me. Charge me with your fucking bullshit crime, and then I'll beat you in court, and then I'll fucking claim the bonds, and then I'll put the revisionary interest on a fucking OID, and I'll pull it down in another $1 million return. Like, this isn't going to end, and you guys aren't going to win with me because you're never going to get me to admit to jurisdiction. You're never going to get me to say something stupid or do something dumb. You're never going to get me to let you have, $42 billion in bonds. It ain't ever going to happen. You work for me. I don't work for you. And so that's the thing, that's what this was all about. And I wanted to share this with everybody. And I've wanted to share this for a while, but I was kind of waiting for them to give me a open door, right? And they did, right? This dipshit lawyer in Wisconsin opened the door for me, and then this idiot got all in his ego and his feels, and then he started going down this road, and it's getting worse for him. It's going to get worse for them. They tried this shit. They tried this shit with the clerk in my home county down here, right? They tried this stuff, with judges. They tried to put me in prison with a 30-year felony, and 4 days later, I got picked up in my socks. I had to walk 7 miles back from the jail to my house in my socks. But this is it. I don't care. I don't care about your ego. I don't care about your court. I don't care about whatever bullshit fucking ego trip that you want to be on because you're honorable so and so. Like, I don't care. I don't care if you're an attorney. I don't care about your fucking bullshit bar association. I don't care about any of it, right? If you don't leave me be, right, you're gonna end up. This is like I tell people, I'm not a hornet's nest you want to kick. Right? I'll be calm and I'll be cool and I'll mind my own business and I'll stay in my lane. But if you kick this hornet's nest, you're going to get a swarm, right? And so they're about to find out. They're going to drop it. They're not going to do anything, right? Because right now they don't have anybody to charge. You got to have a surety, right? So let's just pretend that Stark Financial Group and the Stark Law Firm is doing everything that they say they're doing. Who are they going to charge? Me? I'm a living beneficiary. You can't even get me in a courtroom. You're going to charge my trusts? All my trusts say you can't do what you're trying to do. I got shit on the record. I got 400 or 500 pages of shit on the record in Pima County. So this is a public meeting. This is a public group. This is going to be a public video. This is my standing challenge to anybody out there. If you think you can charge me with a crime, fucking charge me. I'm just waiting for you. So anyway, you guys got any questions about anything I went over? You want to talk about anything? Go ahead and ask.
Brandon Joe Williams recently came up with a video about that very subject, practicing without a law without a license. He said, "I dare you to accuse me of that, and I'll break all the hell loose." Yeah,
Yeah.
he basically said that, coming out publicly stating that I am practicing law without a license. Do something about it. I dare you. That's what he said.
Yeah.
He had like an hour video explaining the whole reason why we can't defend ourselves and we don't need a license. In fact, there's no such thing as a state license.
Yeah.
Bar,
No state has a state issued law license. Nobody.
yeah, Bar Association is a private member association in every state, and it's a private company. It's not a state-run company.
They said, well, in Wisconsin, that got in this discussion. They said, well, I'm accredited to the Bar Association, and according to Wisconsin statute, I'm like, what Wisconsin statute? I mean, show me right now the Wisconsin statute that says that being accredited to the Bar Association means that you have a Wisconsin state issued law license. And they're like, well,
Yeah,
it's an assumption. The assumption is that if you're accredited to the bar, that you're authorized by Wisconsin to practice law. And I'm like, but there's no statute that says that.
That's where you say I rebut all the assumptions and presumptions of this court.
It's their own assumption. It's their own
Yeah.
laws.
isn't
It's
there
their own.
the bar loop also? To get certified, or it's required to be certified, but you got to be certified by the bar to be certified.
Right.
It's stupid.
Right. And
It,
everybody that
it,
works there is a bar attorney. And,
yes,
so
it's
the funny
retarded.
thing is that like they don't have the right to coin lawyer, right? Because lawyer means that you are a purveyor of the law. They don't have a right to the law. They have a right to statute, to legal. They have copyrighted the legality of everything. And the word legal means against God. The law is God's law, right? Is with God. They don't have a right to coin lawyer, right? Because that's, like my ex used to say this. What is a person that makes bows called? A bowyer, right? So what's a lawyer? Somebody that makes laws, right? But attorneys are different. What does a torn mean? To twist, right?
To turn over one's property to the other.
Yeah, to a torn is to twist or to turn over, right? So they're not even the same word. Like lawyer and attorney, they're not even the same word. They don't even mean the same thing, right? So anybody can be a lawyer.
All right. So then tell me this. This is what I've been curious about actually. Attorney in fact, right? This is the authorized representative. If you're an attorney in fact, like why can't you see what I'm saying? Like if you're a factual version, attorney at law, okay? Attorney in fact, like why is that not why can't you just say I'm an attorney either way? Because if you're actually taking and it seems to me that attorney in fact is like you're untwisting it. Like attorney at law is like twisting the law, and
They
attorney in fact is like
copyright, right, but they copyrighted the term. And so what
attorney in
they're
fact.
not saying that you can't be an attorney. In fact, they're saying you can't use the word attorney in advertising because we have it
Oh,
copyrighted.
I see.
Okay. But they're like we sometimes you get confused between what you have the right to do and what they're copyrighting. So in commerce, they have the right to copyright that and they have it copyrighted. And so in commerce, they're saying you can't do that. But I'm not the surety. I'm not coming in commerce and saying I represent this organization, right? I'm coming privately. I am a private man, a beneficial non-surety interest holder. I am not subject to your legal bullshit because I'm private. They don't have jurisdiction over me. They can't enforce the law even if they could prove that it was broken, right? Because I am not what they say I am. They're using the assumption of the name Kent Nicholas Stark, which is the estate, right? You guys remember? You guys remember this? I know where it is. Court stuff.
So my question is, while you're looking for that, why are so if you're acting in the private, you're you fully recognize yourself as a private man. What prevents someone in the private from defending the interests of other private men and women That's just my, I don't know if there's
Well,
something.
that's your remedy is in the private. So what law is the private law?
The
Common law.
laws of the republic, the constitution,
Equity, right?
and equity. Yeah.
Right. So
Laws
equity
of
is your
equity.
remedy. So that's what protects you. I am, I am unalienable. I have unalienable, unenumerated, proprietary, and substantive rights in the private. I'm unalienable. You can't touch me. All right. Remember this? You guys remember seeing this where I put this all out there? Where I put it on all the different buildings in Morgan County? Well, read it. I don't know if I can flip this. Let me try and flip it. Oh, yeah, here you go. Public notice of the Living Estate Trust. Notice is hereby given Kent Nicholas Stark, all in small letters. A living man has formally issued and published the notice of the Living Trust estate concerning the estate known as Kent Nicholas Stark in all capital letters. The living trust state governs the estate granted to Kent Nicholas Stark by the testator, Kent Nicholas Stark in all capital letters, as evidence of the testator's intent and filings of the estate registered with the Postmaster General on August 2nd, 2023, under Master Trust File Number RF 707-545-386 US.072. The trustees have accepted their appointments. The executor, Kent Nicholas Stark, is egressed native, Morgan, Georgian private, civilian national, originally domiciled at 500 Indian Creek Trail, and all times foreign to and without the excluded domestic, territorial, District of Columbia jurisdictions, affirms his standing executor to the foreign estate, Kent Nicholas Stark, all capital letters. So this has been on the record for months, right? This has been on the record for months. This is why you're talking about how do you do this so that you're protected in the private? This is why. This is how you do it. But there's a bunch of stages that you got to go through that we go through in the group to get here. But this is why. This is why they're sending me letters and not charging me because they already know what I'm going to do. They already know I'm going to go in the
I got
car. Go
I
ahead.
got a question on a slightly different subject. When you did your SPC, did you put a lien against the strawman or Ans Legis through the UCC, or did you not do that as part of your
Yeah.
process?
Yeah, I did that.
Is that in any of our documents? I sort
Yep.
of. Oh, okay.
Yeah. And then once you do the trust, then you have to do the foreign grantor trust lien, and then you got to do one on the estate.
Mm-hmm.
Right. So we'll be getting into that soon.
Okay.
And then I did one on this trust too. I used this trust and I did a UCC on that.
Okay.
So all a UCC does, it's a statement of a trust relationship,
Mm-hmm.
right? So we're just expressing that we have trustee, grantor, and beneficiary, right? That's what a UCC does, is it creates that. It's just a statement of a trust relationship, an implied trust relationship is then expressed.
Got it.
All right, you guys got any more questions? We got another meeting tonight. Tonight, I'm going to go over a bunch of stuff. So we got another meeting tonight. So if you got more stuff, we can talk about it then.
Sounds good.
All right. Well, we'll end this. Thanks for everybody for coming.
Heck yeah, always a pleasure.
Thanks, Ken.
Yeah, we'll talk soon. Thanks. Bye.